Hello and welcome back to this series of lectures on handling disciplinary procedures. The last step in the disciplinary procedure, as you know, is appeal, revision and review. So today we will talk about the appeal, revision and review. Now the remedies after a penalty has been imposed by the disciplinary authorities are appeal to the higher authority and also reviewing authority, who can be president and also includes the appellate authority. So the order of the disciplinary authority is not final in the sense that person on whom the penalty has been imposed has the option, or the rule provides for him to submit a representation to be considered by higher authorities. Now, up to 1981, these were the two rules. Appellate authority would consider the representation under Rule 24, and reviewing authority, who was the president, including the appellate authority, would consider the representation under Rule 29. Now, let us say the disciplinary authority for a Group C post is Deputy Secretary. Now, he passes a final order. The Group C official can submit an appeal to the higher authority, and let us say in the rules it is Joint Secretary. So, he can submit his representation to be reconsidered by the appellate authority, who can exonerate the government servant, who can enhance the penalty, who can reduce the penalty, who can set aside the penalty order. The appellate authority can do anything, of course, for reasons to be recorded. Now, after this, the rule also provides that the president will be the reviewing authority. Being the head of the executive, president is the highest authority. So he has this power under Rule 29 to revise the order of the disciplinary authority who is subordinate to him. But the interesting question which arose in the year 1979 in a Government of India case was, what if the disciplinary authority is the president? Now, can the president himself review his own orders passed under as a disciplinary authority? That was the question. Now, look at this case. Now, suppose the disciplinary authority for a Group A officer, as you know, is the president. So, let us take a case of a Group A officer where the disciplinary authority is the president. Now, president passes an order either of penalty or of exoneration, any order. After the inquiry is over, he passes a final order. Now, we know very well that there is no appeal from the order of the president. So, there is no appeal. So, this appeal provision will not be there if the president has passed an order. There is this level of reconsideration is gone. However, the question which arose in 1979, since reviewing authority is the president under the rules, can the president himself, who had issued a final order as a disciplinary authority, can he now review his own orders and change the original order? This becomes more interesting if you think like this, that there is a Group A officer whose disciplinary authority as president has, after consideration of his case, exonerated him initially, and thereafter later president now wants to review the original order of exoneration and wants to impose a penalty. Can it be done? So that is the question which arose in 1979, and the name of the case was R.K.Gupta versus Union of India. Now, before I go there, we will quickly see the text of the Rule 29 as it was then existing before 1981. Now, the erstwhile Rule 29 says that notwithstanding anything contained in these rules, the president, as you can see, the president may at any time, either on his own or its own motion or otherwise, call for the records of any inquiry and review any order made under this rule, and then confirm, modify or set aside the order, or confirm, reduce, enhance or set aside the penalty, or impose any penalty where no penalty has been imposed. So, under the review powers, the president could review the orders passed by the disciplinary authority. The question was, can he review his own order? Now, the facts of the case of R.K. Gupta are very interesting. R.K. Gupta was appointed as a Class 1 officer in the year 1969, recommended by Union Public Service Commission, and he was working in the Ministry of Industry. In his office, there was a director DGTD, the Director General of Technical Development, Dr. Kalilkar. In the middle of August 1969, a calling attention motion was tabled in the Rajya Sabha, in which the member of the parliament produced a letter allegedly written by the director DGTD, that is Dr. Kalilkar, to a private firm demanding some illegal gratification for doing some favoring some work for that private firm. So there was an investigation carried out, and the needle of suspicion actually fell on Mr. R.K. Gupta. It was found that Mr. R.K. Gupta had allegedly forged the letter and personally handed over the letter to the member of parliament so that they can raise the matter in the parliament with the ultimate objective of maligning the director. So Mr. R.K. Gupta was charge sheeted vide office memorandum dated 18th August 1970. The charge had two parts. I would request you to carefully see this. The charge had two parts. The first part of the charge was that Shri R.K. Gupta had handed over personally this letter to Shri N.P.C. Naidu, who was a member of parliament, and other members of the parliament, so that they could raise the issue in the parliament with the ultimate objective of maligning the director, Dr. Kalelkar. This was the first part of the charge. And second part of the charge was that he had forged the letter. So second part of the charge was that Shri Gupta had forged or caused to be forged a letter dated so and so, purporting to have been addressed by Dr. Kalelkar. Now, after the charge sheet was issued, an inquiry was conducted. Inquiry was conducted by the Commissioner for Departmental Inquiries. As you know, a list of officers maintained by the Central Vigilance Commission of those persons who are highly experienced in conducting inquiry. So the Commissioner for Department Inquiry conducted the inquiry and submitted his report. In the report, the Commissioner for Departmental Inquiries found that the charges could not be proved beyond doubt and exonerated Shri R.K. Gupta. This was his recommendation. The matter was considered by the President, and the President, agreeing with the report of the Commissioner for Departmental Inquiries, dropped the charges. So the text of the order, or the language or the phraseology in the order issued by the President exonerating Shri R.K. Gupta would be interesting to read. Now, the charges were dropped by the President by order dated 1973, and with reference to the two parts of the charges, you remember there were two parts. R.K. Gupta had personally handed over the letter, and second was he had forged the letter. So regarding the first part of the charge, that he had personally handed over the letter to the members of the parliament, the President, agreeing with the Commissioner for Departmental Inquiries report, recorded in the order that the President, after careful consideration of all the circumstances of the case, agrees with the findings of the inquiry officer that part of the charge, namely this, that he had handed over the letter personally, has not been established at all. So this was the words written in the President's order. And this to the second part of the charge, that he had forged the letter, the President recorded in the exoneration order that there is some evidence that the document may be forgery, but there is hardly any evidence to prove that Shri R.K. Gupta was responsible for the same. As such, this part of the charge is not proved beyond doubt. Kindly see the words used in the order, has not been proved beyond doubt. Now, obviously at this stage, I just remind you that you know that in departmental cases, the standard of proof that we require to prove a charge is not used in the criminal case. In criminal case, we used beyond reasonable doubt. A charge has to be proved beyond reasonable doubt. That is not what we use in the departmental cases. We use the standard which is called preponderance of probability. ज़्यादा probable लग रहा है तो charge prove है, उसमें beyond doubt prove करने की आवश्यकता नहीं है. So anyway, but in the orders, the departmental inquiry, the Commissioner for Departmental Inquiry and the President both applied the stricter standards of proof of a criminal law. Anyway, and the operative para of the order issued by the president was that in these circumstances, the president considered that Shri Gupta may be given the benefit of doubt. Again, the idea you can see is they are applying the standards of a criminal law. Whether it was required or not, we will see later. But the benefit was given to Shri Gupta, and the charges framed against him may be dropped, and the president orders accordingly. So this was the happy ending of the story. Now, post exoneration, the period of suspension from 1969 to 73 was treated as duty. So, Sri R.K. Gupta's 4-year period was treated as duty, and full pay and allowances was given to him. So, R.K. Gupta was very happy, and apparently the entire period, the entire experience, the bad experience came to a good end, a happy ending. However, this happiness was short-lived, because 2 years later, the president issued him a memorandum. That is, in 1975, a memorandum was served on Shri Gupta, informing him that the president had undertaken a review under Rule 29 of his earlier order dated 4th September 1993, in which he was exonerated. So, president had reviewed his exoneration order earlier, and now the president informed Shri R.K. Gupta that it is proposed to impose a penalty of dismissal on Shri R.K. Gupta. So now you can understand the president who had issued the order as a disciplinary authority exonerating R.K. Gupta, the same disciplinary authority 2 years down the line changes his opinion and now imposes a penalty of dismissal, and proposed to impose a penalty of dismissal, and a representation was sought from Shri R.K. Gupta. Obviously, R.K. Gupta went to the court. So obviously, you would like to know what was the reason that the president had reviewed his order. Can the president review his own order after having considered all the materials, all the evidence? Can he change his order, review his order and change it? That was the question, as I said. So what was the reason? The reason for the review of the president's order, as I have briefly discussed earlier, that the Central Bureau of Investigation felt that the Commissioner for Departmental Inquiry, one who conducted the inquiry, so CBI said the inquiry officer had assessed the evidence more like in a criminal trial. He had applied the standards of beyond reasonable doubt. There was no need for it. The standard of proof required in departmental inquiry is, on the other hand, preponderance of probability. So it is a little lenient standard of evidence and not the strict standard of evidence of proof beyond reasonable doubt which is required in criminal law. So the CBI advised the president that the president should apply the test of preponderance of probability. Interestingly, there was the reasons for review was only this, only the different standards of evidence applied by the president. There was no suggestion that any fresh material had become available which had led to the review of the earlier judgment of the president. There was no suggestion also that Shri Gupta had made any misrepresentation which had led the disciplinary authority to conclude something which he should not have concluded. There was no such suggestion. So the sole reason for review was applying the different standards. Should preponderance of probability be applied, or proof beyond reasonable doubt? So now the president applied the lenient level of lenient standards of evidence, which is preponderance of probability applied in disciplinary matters, and came to the conclusion that some penalty should be imposed. Obviously, when on a class 1 officer a penalty is proposed to be imposed, UPSC has to be consulted. So UPSC was consulted. UPSC also advised dismissal. So UPSC was consulted and they advised dismissal. So R.K. Gupta appealed in the Delhi High Court. Union of India was respondent, and the argument put forward by the Union of India for taking this action, that is the president reviewing his own orders, was that The Union of India argued that the right of the President by virtue of Rule 29 to review his earlier orders is without any limitation and constraints. So no limitation can be imposed under Rule 29. The President can review his earlier order, and the reasons given were that if an earlier order passed was erroneous, it should be open to the authority to recall that order in the larger public interest. And if a government servant has been exonerated even for extraneous reason by the disciplinary authority, there would be no remedy, and this would certainly be against public interest. So if some extraneous reasons have been taken into consideration, how do you remedy that? So the Union of India was of the opinion that under Rule 29, President can review his order anytime. The High Court's final judgment came in November 1979. I am not going into very detailed. I would request all the participants to find time and do read the judgment on their own. But the main points of the judgment were that the court referred to the revision and review, which is very much part of the Civil Procedure Code. So under CPC, there is this provision of revision and review by the courts. The terminology revision and review have different meaning. Revision is a reconsideration of the orders of a lower court by the High Court. So under the CPC, revision, the powers of revision is only with the High Court. Lower courts cannot do revision. So obviously, High Court as a higher authority is reconsidering the orders of a lower court. So revision has this connotation of a superior reviewing the order of a inferior authority. Whereas the word review is reconsideration of the order by the same court, by the same bench. So review is by the same court or the same bench. Revision is by a higher authority. So the High Court Delhi referred to these issues in the Central Civil Procedure Code. And it also came to the conclusion that the text of Rule 29 makes it very clear that it is actually review in the revisionary sense. That is to revise the orders of a subordinate authority. The Rule 29, the language used, gives the very clear conclusion that the review word used in Rule 29 is actually revising the orders of a subordinate authority and not revising the order of the same authority. So the same authority, after passing an order, cannot revise its own order. So the court further held that the power to review one's own order is not an inherent power. It must be conferred by law either specifically or by necessary implication. So it said that Rule 29 does not specifically mention, nor there is an implication that the President can review his own order. Of course, he can revise the orders of a subordinate authority. So President, under the power of Rule 29, can revise the orders of a subordinate authority, but not his own orders. And to the Government of India's argument that, if something extraneous has been taken by the disciplinary authority or there is an error, how do you correct it? The court said the risk of a subordinate authority passing a palpably wrong order is removed by the overall powers of the President to review under Rule 29. So President has the overall power to review the orders of any authority subordinate to it, and if there is something wrong, he can set it right. So consequent to the judgment of the High Court, the Government of India amended the rules, and the Rule 29, which was for review, was changed to revision. So Rule 29 gives the power to the President to revise the orders of his subordinates, and a new Rule 29A was inserted by which the President can review his own orders but only under very limited circumstances. So Rule 29A provided for review of the President. President can review his own orders, but not just like in whims and fancy. There are very limited grounds on which he can review, and those are. So now you can see the 29A, which was not there, was inserted, and it says the President may at any time, either on his own motion or otherwise, review any order passed under this rule, but when any new material or evidence is available. So if there is only new material or evidence which is available, but which could not be produced or was not available at the time of passing the order under review. And further, not only a new material is now available which could not be produced at that time, but it should also have the effect of changing the nature of the case, so that any new material or evidence will not be considered under review. It has to be so important that it has the effect of changing the nature of the case. So only under these limited ground the president can review his own orders. In the R.K. Gupta's case, there was nothing like that. No new material or evidence was available. The only reason the president reviewed the order was he applied a lenient standards of evidence, that is preponderance of probability, and felt that by applying the preponderance of probability, the charge which was earlier could not be proved now stands proved. So that is not the contemplation under the concept of review. However, today a president can review only under these limited grounds of new material or evidence which has the changing effect of changing the complexion of the case. In the part 2 of this series, we will talk about detail about appeal, revision and review. But before I conclude, just a comparative chart. What is the difference between appeal, revision and review? You can see that appeal is to the appellate authority, who is normally higher than the disciplinary authority. And how can appeal be made? Appeal has to be made by the individual within 45 days from the date of the order of the disciplinary authority. Coming to revision, the power of revision is with the appellate authority and the president. However, this can be on own motion or otherwise. That means even if the person has not submitted a representation for revision, the revisionary authority on his own can call for the records and revise the order of the lower authority. That is not there in appeal. In appeal, if a person does not appeal, then the appellate authority on his own cannot pass an order as an appellate authority. Now, when can revision be made? It can be made any time after the period of appeal is over. Period of appeal is 45 days. So the process of revision can be started only after 45 days, not before that. And or if the person has submitted an appeal, then the appeal has to be disposed of. Only thereafter the revisionary authority can start the process of revision. Coming to review, that is the last on the rightmost part of the table, review. The power of review, as you can see, is not with anybody else except president. So only the president has been given this power to review his own orders. But as you remember, the condition is there has to be a new material which could not be produced at the time when the final order was passed by the disciplinary authority. Of course, there is this larger question that for review, no time has been prescribed. It can be done any time. So it could be after 1 year, 2 year, 3 year. On this, we will talk in the subsequent next lecture. But at this moment, for this, I think it is sufficient to make you hungry for the next video on this, that what is appeal, revision and review, who can do it, what is the process, how to handle it. We'll talk in the next lecture. So thank you very much. Bye bye. See you soon with the next video on how to deal with appeal, revision, review.